Good afternoon, everyone. I'm Beth Hinson, and I chair the Privacy and Cybersecurity practice at Morris, Manning & Martin. We're very pleased that you've taken time out of your Friday afternoon to join us. We look forward to presenting to you on cybersecurity and privacy risks specific to the COVID-19 crisis. I will be joined today by my colleagues, Ashley Thomas and Bissy Adeyemo, both of whom are associates in our cybersecurity and privacy practice. So starting off, as you've seen in recent headlines, all businesses, employees, even your customers are increasingly relying on home networks, virtual workspaces, video conferencing, and other forms of remote work, which unfortunately opens the door for cybersecurity concerns. By moving our businesses to a remote setting, we are collecting additional personal information and creating new repositories of this personal and also health information about our employees and customers as a result of the pandemic. There's really no more important time for us to adhere to cyber and data privacy best practices. As you can imagine, the regulators' views on the sharing of personal information are rapidly changing as we're having an urgent need to share certain personal information about employees and even customers in some cases. But there will be a review of our data sharing practices inevitably once we get through this pandemic. And it's really, the best approach is to make sure that we're adhering to our best practices. Over recent weeks, various federal and state agencies and industry groups have issued additional guidance and information about how we should be treating personal information during this time. They've also issued guidance and published information about new and increased cybersecurity threats that we're seeing. So during our webinar today, we will discuss some of this new guidance. We'll also discuss the threats that we are monitoring and in some cases our clients are unfortunately experiencing in these recent weeks since the shift to the remote workplace. A lot of those threats include phishing emails, which use the subject of coronavirus as a lure to our employees. We're also seeing malware distribution, again, through coronavirus-themed lures. Registration of new domain names containing wording related to coronavirus or COVID-19. So as your employees are working from home and also looking for information on the pandemic, they may be brought onto sites that are not good for your company. And we're also seeing new attacks against these rapidly deployed remote access and teleworking infrastructures. For example, actually this past Wednesday, the United States Department of Homeland Security, Cybersecurity and Infrastructure Security Agency, as well as the United Kingdom's National Cybersecurity Center, issued a joint alert warning of a substantial increase in these attacks. They provided some helpful guidance concerning the attacks as well, which we'll cover. And part of the concern is that individuals who are working from home may be clicking on links while they are logged into the virtual private network, right? In addition to that, we've seen a malicious Android app that's purporting to provide real-time coronavirus outbreak tracker information, but instead it's tricking the user into providing administrative access by installing a so-called COVID lock ransomware on their device, right, which is quite horrifying. In addition, we're seeing industry-specific regulators issue guidance and in some cases a request for descriptions of cybersecurity practices that are being implemented during this time of increased threats. So for example, the New York Department of Financial Services, which regulates financial service companies, and that includes the insurance sector, they requested specifically of virtual currency businesses to provide assurances of their plans to address and respond to COVID-19, including their plans to address cybersecurity risks as a result of the pandemic. We're also seeing increased activity coming from the U.S. Federal Trade Commission, which is cautioning businesses that cyber attackers are using fake and fraudulent emails and text messages to get recipients of those messages to share account information, login IDs, and passwords. Further to this point, the U.S. Securities and Exchange Commission, while they have ordered conditional relief for companies affected by COVID-19 by permitting an additional 45 days to file disclosure reports, they have noted that once companies in fact file these disclosure reports, they should be providing investors with insights regarding their assessment of and plans for addressing material risks related to their business operations. One of these potential risks, of course, can relate to cybersecurity. As you know, public companies are required to disclose cybersecurity risk factors. And so what's important to ask if you are in fact filing is, in what industry do you operate? What new risks might present themselves from a cybersecurity perspective, given the remote work arrangements? What adverse effect might this have on your ability to maintain operations, including security controls, right? I mean, if you think about it, if you, for example, operate a call center and employees within that call center answer the phone and have access to, PCI DSS covered information or sensitive information where they're answering questions from customers who may be providing, last 4 digits of socials or, last 4 digits of payment card information. And you have no ability to sort of monitor how those employees leave their desktop or their workplace. How are you policing their ability to, not capture that information on documents that could be exposed or be authorized or accessed rather without authorization, right? And so we're certainly having to get creative when it comes to addressing the implementation of security controls at home, where employees may not just use the laptops that we're able to monitor, but paper and pen, right? So let's go through to slide 6 now and talk a little bit more. Make sure I think I still have control here. Yes, on steps to address remote workforce cyber risks. At this point, now that we're speaking to each other, I'm presuming that most of your employees are in fact working from home and you've made that transition. Even though you've already made that transition, it's not too late to consider these risks. It's not too late to reinforce, and I recommend that you do so on a weekly basis, the need for good cyber hygiene and good practices at home. So, as various agencies have noted, in fact, there is a continued uptick of phishing attempts, and you should ask your employees to report phishing emails. This is not a time to stop your email phishing campaigns or testing within your organization. Make sure that your information security team or information technology team, while they are making sure the day-to-day is operational, right, we should still be deploying those weekly or monthly phishing tests of our employees so that we can monitor the fact that they are not clicking and are not susceptible to those attacks. We also need to be particularly mindful of practices within our accounting departments at this time, practices of your chief financial officer, individuals who are likely to be targets of cyber criminals. It is not a good time to be losing money to a fraudster, right? Whether that's with your customers paying outstanding invoices or the business itself paying its invoices. And so employees who work within your accounting department, there's going to be a great temptation to communicate over email or over text message, particularly where our employees have varied responsibilities, including homeschooling, right, during this time, and you may not want to be too intrusive. I think now more than ever, we should be using the phone and advising our employees to use the phone to verify any changes in bank routing information. If you have not instituted multi-factor authentication, that's something else you should consider as well. You should encourage your employees to turn off their smart speakers at home, right? Advise your employees not to download or transfer company information to their personal devices or to third-party cloud storage accounts that they may be tempted to use when they don't want to bother an IT professional, or when the IT professional is not a few offices down the hallway currently. We should also be encouraging the minimum necessary use principle, which means that our employees should not be storing company confidential information unnecessarily. And as you can see on the slide, just a few more recommendations regarding the ability to encrypt data. And as I mentioned, it's important to establish a policy for the use of third-party cloud-based applications. So I also want to discuss the fact that now would be a very inconvenient time to experience a cybersecurity incident. Not only are we trying to run our businesses remotely with many different video conferences and meetings and trying to reach people on the phone when they're managing their home responsibilities as well during the day. But unfortunately, I think we are going to see an uptick in cyber attacks and evidence of intrusions that will need to be analyzed. And so where you have an incident response plan, make sure you review it and update it as necessary to address deploying that plan, acting upon it with a remote workforce. Given the heightened responsibilities of our information technology professionals, do we need to designate responsibility to another individual? Do we need to revise the plan? Do we know who we're going to call when it comes to our outside counsel? Do we have a preferred third-party forensic investigation firm, a notification vendor? Have we touched base with our cyber liability insurance broker recently? It might be a good time to pull out that cyber liability insurance policy, make sure you know what steps you have to follow in the event that you have an incident. So I wanted to touch briefly on security concerns for furloughed employees. This is something that, I'm not an employment law expert, but given sort of the option to furlough employees, particularly if you are eligible for some of the loans that are being made available to small businesses, we do need to keep in mind the fact that as we furlough employees, they should not have access to company confidential information. And there may be changes that need to be made in our IT infrastructure. We turned on remote access. Some of that electronic access would need to be disabled. We'd also need to have a plan for returning company-owned devices or laptops, and where necessary, remote wipe devices that are held by the employee. So in terms of the next slide, I would like to turn this over to my colleague, Ashley Thomas. And she's going to present on some of the privacy considerations for employers, as well as considerations related to health information.
Thank you, Beth. If somebody could advance the slide. Sorry, having a little bit of technical difficulties. If Mike could take control and advance the slide, I would appreciate it. So moving on, as businesses are grappling with the coronavirus, they are facing numerous privacy issues. While the U.S. does not have a comprehensive federal law in comparison to other countries, the U.S. has kind of a sectoral-based approach to privacy laws. So the telecommunication industry has privacy law-specific regulations, healthcare does as well, banking and financial institutions. So businesses in dealing with the coronavirus and potential privacy implications need to evaluate their industry-specific privacy laws that may be applicable to them, as well as emerging state laws and industry best practices that may apply to them for guidance and direction on how to manage some of these privacy issues that may arise. As a general matter, it is not advisable for organizations to collect more personal information, particularly sensitive information that is needed for valid business purposes or is otherwise required by law. In the case of a public health crisis like this one, business priorities often shift to incorporate considerations around public health, and the collection of personal information should be balanced against those objectives. Privacy laws in the U.S. generally limit the sharing of personal information, particularly health information, but certain exceptions may apply. In general, healthcare providers are permitted to report positive diagnoses of communicable diseases to public health authorities, while there is typically no express obligations for private entities outside the healthcare sector to make those disclosures. And if I could advance to the next slide. Hopefully, I'm sorry, my screen is no longer showing any slides. So hopefully we have now moved on to turning into looking at specific federal laws that may apply. So the first one is Americans with Disability Act, commonly known as the ADA. So the ADA protects applicants and employees from disability discrimination. And it is relevant to the current pandemic because the ADA regulates employers' disability-related inquiries and medical examinations for all prospective employee applicants and employees, including those who do not have ADA disabilities. And keeping in mind that the ADA applies to employers with 15 or more employees. So we should currently be on slide 14. And so looking at one of the questions is, how much information may an employer request from an employee who calls in sick? And I understand that some of employee businesses may be working remotely, but some businesses may still be operational, so this potentially could apply to you. So the Equal Employment Opportunity Commission, which has oversight and enforcement discretion with the ADA, has come out and said that employers can ask their employees if they're experiencing symptoms of the pandemic virus, and in this instance for COVID-19, if you're experiencing fever, chills, cough, shortness of breath, or sore throat, the employer can ask the employee. However, the employer must maintain all this information as confidential as part of the ADA confidential medical record in compliance with ADA. Now turning to slide 15, what should an employer do if an employee has confirmed that he or she has COVID-19? So if an employee has confirmed with their employer that they have tested positive for the virus, The employer can inform other employees who may have potentially had exposure to that individual, all the while maintaining confidentiality as required by the ADA. The employer should share only the minimal amount of personal information necessary to enable the individuals who may have been affected to assess their own personal health and potential exposure. Now turning to slide 16, looking at the Telephone Consumer Protection Act, which regulates automated voice and text messages to cell phones, is also commonly known as the TCPA. If your business wants to use voice or text messaging to communicate with employees or customers during this period of physical separation and social distancing, then your business will need to be mindful of the TCPA. Even if the text message or call contains, it's only for purely information purposes and not marketing, you still need to be mindful of TCPA requirements. The Federal Communications, which governs and has oversight over the TCPA, has issued a guidance most recently on March 20th saying that the coronavirus does constitute an emergency purpose, which is an exception under the TCPA, and it applies. Healthcare providers, hospitals, and state and local governments can all send out emergency communications. However, businesses should still be careful in evaluating whether their proposed voice or text message will fit within that exception under the FCC guidance. So also keeping in mind for those in the financial institution and banks, they are pushing for guidance from the Federal Communications Commission to allow them to send alerts regarding scams, branch closings, and also information related to mortgage and loan payments to see whether that would be permissible as an emergency under the TCPA. So the FCC could be coming forward with future guidance sometime. And then moving on to slide 17, looking at the Health Insurance Portability and Accountability Act, also commonly known as HIPAA. So in general, HIPAA will not apply to an employer's activities purely because a private business would not be considered a covered entity under HIPAA, and a covered entity is defined as a healthcare provider, health plan, and healthcare clearinghouse. So typically, private businesses don't have to worry about HIPAA, with the exception being employers that sponsor a self-insured medical plan or an insured medical plan for which they receive protected health information. Then they will need to be, they will be obligated to comply with HIPAA's obligations. And with that, I will turn it over to my colleague, Bissy, who will talk about the GDPR.
Thank you, Ashley. So the COVID-19 pandemic has had a number of implications on employers that are required to comply with the General Data Protection Regulation, or the GDPR. The GDPR provides legal grounds generally for employers to process personal data in the context of pandemics without obtaining legal grounds for without obtaining individual consent. Recently, Andrea Jelinek, the chair of the European Data Protection Board, issued a statement with regard to processing personal data. According to the EDPB, the GDPR does not hinder data controllers from protecting against COVID-19. However, controllers must ensure protection of the data it collects. Additionally, data protection authorities, or DPAs, have also published guidance on employers processing personal data. For example, the French DPA provides that organizations may not implement measures that would infringe on an employee's right to privacy, especially by collecting personal health data that is beyond what is necessary to determine potential exposure of the virus. The United Kingdom's Information Commissioner's Office recommends that organizations inform employees about COVID-19 cases. However, organizations do not need to identify the individuals or provide more information than is necessary. We've also seen from the Belgian DPA, which has stated that organizations cannot conduct systematic controls, such as body temperature controls, with respect to their employees. Furthermore, the Belgium DPA has discouraged mandated medical questionnaires or questionnaires related to an employee's recent travels. Rather, organizations should encourage their employees to voluntarily report such information. We're also starting to see some guidance from the data protection authorities with regard to the enforcement of the GDPR. Recently, the United Kingdom's Information Commissioner's Office has advised organizations to prioritize other areas over data protection practices, that it will not penalize organizations during the pandemic. And I will now turn it over to Beth to discuss some of the laws that we're seeing in the United States.
Great. Thank you, Ashley and Bissy, for covering that material. So what seems like a long time ago now, but actually is not too far off in our recent past, was all of our efforts where we were required to do so to comply with the California Consumer Privacy Act. The act itself went into effect on January 1st of this year, and the act will be enforced, and it's stated in the law that it will be enforced either as of July 1st, 2020, or potentially sooner when, or actually it would be later now that the implementing regulations are not quite finalized yet. But the date we're concerned about is July 1st, 2020. There has been some discussion and also some requests submitted by influential companies to the California AG's Attorney General's office that the enforcement be delayed given the COVID-19 circumstance. So far, we've heard from a spokesperson from the California Attorney General's office stating that the Attorney General has no intention to delay enforcement, and the law will in fact be enforced as of July of this year. The CCPA, it primarily covers consumer data that you may have collected for employers. CCPA exempts personal information collected in the employment context, but there's still, at least until January 1st of 2021, but there is still an obligation to inform employees of the categories of personal information that are being collected about your California employees, right? And so given that employers may be collecting additional personal information about their employees in light of the pandemic, including some health information that would normally not be collected, you may need to consider revising your employee privacy notice soon or before the July 1st date. The other, here, I'm going to move on over. The other law that I want you to keep in mind, even during this time, is the New York SHIELD Act, which went into effect on March 21st, 2020, right as we were all migrating our offices to home. The SHIELD Act applies to any business that retains computerized private information of New York residents and essentially imposes a requirement on all businesses, including small businesses, to establish a data security program and sort of prescriptive administrative, technical, and physical safeguards. Businesses that do not comply may be subject to a civil penalty. So if you've not taken a look at the New York SHIELD Act, it's another one where if you're not in compliance, it's going to take some time to come into compliance. The New York Attorney General is particularly active in this space, and it would be worth looking at over the next few months if you haven't already. I think I might have skipped too far ahead. No, maybe not. All right. So one of the other topics that we wanted to discuss in our presentation today has to do with conflicts between privacy concerns and an adequate pandemic response. Well, as you've heard from the news so far, there are now companies, Verily is one of them, a Google organization that is launching a web-based assessment platform of COVID-19 related symptoms to advise individuals as to whether or not they need to seek additional medical care or evaluation. The information that is shared will be passed on to healthcare professionals and potentially other federal, state, and local authorities, and potentially with Google, which owns the company. Here we go. Okay, I apologize. Some of the text in my outline was in the wrong spot. So, as is apparent with some of these surveillance efforts, it's really going to open up the door to location tracking as well, because part of our efforts to slow or stop the spread of this disease, or this virus rather, is to in fact know that individuals are isolating and staying away from others. So we are seeing guidance that has been issued by various data protection authorities, including those that are in the European Union. The United Kingdom's Information Commissioner's Office has in fact granted the UK government permission to anonymize mobile phone tracking data in order to tackle the spread of the coronavirus. The data will be anonymized and used to create movement maps. This effort has been used in other countries. The ICO is claiming that if it's properly anonymized and aggregated, it would fall outside of existing UK data protection laws and the GDPR. The Washington Post and other news organizations here in the States have stated, or reported rather, that US government is considering similar moves. Further to that point, Israel's health ministry has publicized certain dates, times, and location information related to people with the virus. They've in fact launched a mobile app which uses geolocation technology and sends a text message if an individual has crossed paths with another individual who has the virus. In Poland, technology is being used to sort of advise individuals who have traveled abroad to self-quarantine, and it's utilizing facial recognition as well. These users are randomly prompted throughout the day to submit a selfie, and if they fail to respond, authorities are alerted. So this is certainly an interesting evolution in sort of the location tracking case law or common law, so to speak, as there have been fines proposed against our largest wireless carriers for selling access to customer location data. In this case, it's being used for public health purposes, for legal purposes. We are aware of the fact that cell phone information has been used in law enforcement activity, but it's certainly something to watch going forward. So as I mentioned, facial recognition technology, taking a selfie, submitting it to the government. We're also in new territory related to biometric collection. Biometric data collection. If you think about it, Will we return to the handshake? I hope so. But are we going to return to a desire to want to open our office doors and press elevator buttons? Will that present new risks for us, particularly in the next year or so until a vaccine is created and distributed? These circumstances might incentivize our businesses to invest in touch-free systems for security and for time entry. The engagement of those technologies would ultimately necessitate, the use of additional vendors, contractual agreements whereby we may be sharing employee biometric data with those third-party vendors. Will require, additional scrutiny of those vendor security practices. There are state laws that govern the collection and processing of biometric data. Those laws exist in Illinois, Texas, and the state of Washington. There's just a few examples of companies that are in fact developing biometric hardware and adapting their hardware to detect the temperature of individuals. Dermalog is one. And again, we see the use of facial recognition technology in Russia. So something else that comes to mind during this time is that there is an opportunity to innovate, right? Not only to solve the problems that are presented to us as a result of the pandemic, these very unique and novel issues, but also to think about how we collect personal information, how we're securing it, and as a result, we are seeing sort of some tech platforms convert existing products and services to serve the public and providing sort of telehealth medicine, as we've seen, additional mental health services. We've sort of seen that develop in recent years with the ability to speak to a mental health professional via a mobile app, for example, as well as blockchain-based applications to track the spread of coronavirus. In fact, the United Kingdom's Department of Health and Social Care have established the TechForce 19 Challenge, which aims to increase community support for the elderly, the vulnerable, and self-isolating. We're also seeing additional funding for tech companies that are willing to develop technologies that will assist with monitoring aspects of the outbreak. The Israel Innovation Authority is one, as well as the European Commission. Which leads us to ask, what are the privacy implications, right? So, as you or your company is utilizing your time and talent to perhaps launch a new product or service, we are needing to be mindful of the privacy implications, and not only with respect to sort of the Federal Trade Commission's authority here in the United States, but also in various jurisdictions around the world, including the European Union and the various member states, and the myriad guidance that we're receiving from the data protection authorities there to solve for these novel issues. So, the guidance, quite honestly, is changing on a daily basis. On a weekly basis, it is evolving. We are seeing arguments from both sides. One side being, we can't open up Pandora's box and allow our country or other countries to become surveillance states, whereas there are arguments on the other side that it's necessary to save lives at this time. I think without a doubt we are going to see some clawing back down the road of some of the permissions that have been granted during this time, particularly coming out of Europe. And going forward, I think it's best to stay the course and trying to comply with laws as they exist today. And to the extent that there is need to share more or collect more personal information than would be your normal practice, it needs to be limited in nature, and it also needs to be performed within a limited time period in order to establish the arguments one would need to make if they were later scrutinized by a regulatory authority. So with that, we're about 45 minutes into our presentation. I want to make sure we leave time for questions. So I don't see any questions posed yet in the Q&A box, but I will open it up for questions at this time. All right, so it looks like we have a question. The question is, how many of the recommendations do we advise clients to have and include in a code of business conduct form and require all employees to sign? I'm assuming, do you refer to recommendations regarding sort of the use of information at home, company information at home, and whether or not they've taken a phishing training course? Let me see if I can find the Q&A. Oh, here we go. Okay, great. Yep, use of company information, et cetera. Yes, so look, I think it's very important to submit a notice and guidance to your employees so that they have an opportunity to review everything that you expect of them in terms of the best practice while they are working from home. You should absolutely obtain a signature on that form, an attestation that they have reviewed your expectations and they agree to comply. Of course, with what I have in mind there is that if you have an employee that just has a lot of sensitive personal information or confidential information of the company at home, is not disposing of it properly, is not thinking to shred it or tear it up before disposing it, right? And that comes to light, you would want to, and you had a need to discipline that employee, you would want to have that attestation that had been signed and evidence of the fact that that employee had reviewed your guidelines when you come back to them. I think this is particularly an issue when it comes to employees and their temptation to store company information, perhaps in a personal cloud storage space online during this period, right? Because again, they may not want to bother IT. Some of your IT professionals, if you've cut back on hours for any of your employees, or if they're working part-time, they may not be readily available at a time when someone is trying to fulfill their responsibilities, right? And so there may be a temptation of, well, I don't want to wait until Monday at 9 a.m. Because that person is technically, off for half of this afternoon, Friday afternoon, and I need to get this done. So I'm going to store it here or share it this way with a customer or a prospect, right? And part of the concern there, and this is something to keep in mind as well, I'm sure, even I and I think law firms are thinking about, sort of the Zoom controversy right now, where we are all reliant upon video conferencing, but we also want to be careful about what we're representing to our clients about our business practices in using certain platforms these days, right? So, for one of your clients or customers to receive a share file from Google Drive when they normally, receive access to data through, a share file that's internal to the company, it may raise eyebrows, particularly if that customer has asked you to represent in certain contractual agreements that you implement certain security measures and protocols, right? And so it can create great risk to the company where there appears to be any lax security procedures, given that we're all working from home, right? And that's part of why I think it's important to continue to educate, to absolutely give written notice of what your expectations are of employees, and to police it and enforce it. Any other questions from the audience? I see a few questions regarding a copy of the presentation. We absolutely will send around the deck to participants if you've not received a copy already. Okay, so I'll give it another minute for any other questions from the audience. Okay, I think I see one more question, which is, what would guidance to companies be when they see the importance of additional precautions in teleworking and implementing extra measures while we're dealing with COVID-19, but when the environment turns or returns back to normal and employees are back in the office, and companies no longer see the value of the extra cost and capital of IT infrastructure, cybersecurity insurance policies, et cetera? Well, let's see. So I guess, you know, the importance of additional precautions, you know, I think that the message of this webinar is, you know, the precautions that we're recommending are precautions that should have been in place already, many of them, right? Advice against or advice on current phishing email schemes, right? I mean, those schemes still exist. They're only changing now to prey upon the fears and the interests of the general public, right? Which includes your employees who are just as interested in COVID-19 medical expert information as anyone else, right? And so, you know, one of the important aspects of the recommendations we're making is that, you know, we need to be as vigilant as we always would be, if not more so, and provide, you know, more tailored messaging around the types of risks that we're seeing. You know, the work from home scenario, you know, our IS and IT teams do have less control and insight just by virtue of everyone not being in the same building or within the controlled environment that we expect. Instead, you know, our teams are monitoring logins from home, and there's a temptation of employees, and this temptation exists if they normally are able to take a laptop home, but many of our employees who don't normally work from home in the same way that maybe lawyers on this call do, you know, they are not accustomed to logging into a VPN. So again, there's the temptation of, well, I can't gain access to the VPN. Let me just use my home network for a while. I'm going to edit this document, and then it's sort of exposed in ways that it wouldn't be if you were on the VPN, right? So much of the guidance that we're issuing to you know, a work from home workforce is guidance that we should be implementing and providing to any employee who ever works from home. But now, cyber criminals know that there are larger populations that are vulnerable, and they're taking advantage of this. And so when you come back to your normal work environment, you're back in the office. I think what is important is to leverage the new guidance that has been provided and make sure that you're still implementing it. I think it's also going to be important when you come back into the office to assess what new personal information you've now collected as a result of this crisis, and what are you going to do with it? Is there a legal need to retain it? Can you get rid of it? Would getting rid of it remove some of the risks that might have been created during this time? How are you going to know when you come back into the office what information may have been stored in third-party systems unbeknownst to you, right? What might be a prudent way to take inventory or to audit that issue? That's also important. And it's always time to look at and assess your cyber liability insurance policy. I don't care if it's now, if it's 3 months from now, when hopefully we're back in a normal business environment. So I did mention disabling smart speakers. Every iPad, iPhone, or smartphone has a mic that could act as a smart speaker. So how would you handle that? Well, I don't have Siri turned on my phone. I really don't. I think, Amazon Home, or not Home, but Amazon Alexa, Google Home, that is something that you should advise, and again, particularly as employees, or not employees, but as lawyers, having one of those speakers in the room where you may have your home office set up is probably not a good idea. Anyone having a call with sort of confidential communications, again, probably not a good idea to have Siri turned on. It's something that in my own practice, I don't have it turned on. So, if they have an iPad, iPhone, all of those devices in the same room, again, go into settings. You can send a recommendation and instructions on how to disable those settings, either by email or in sort of a one-page PDF, making people aware that there are risks that are created by having those devices turned on. We have just a few minutes left. Any other questions? All right. Well, thank you for your time this afternoon. I really appreciate you tuning in. We covered a lot of ground. There's certainly nuance involved to some of this guidance that's being issued by regulators currently, particularly for specific industries, as we mentioned with the healthcare industry, virtual currency industries, and the financial sector. We're happy to provide you with additional guidance. If you'd like to email us, our contact information is on the slide in front of you, or call us directly. We are available, and I hope that the slide deck and the presentation has been helpful to you. So with that, thank you again for joining, and I hope that everyone has a good weekend.